you tonight on 505. So, suspended Chief Justice Gertrude Torkornoo this afternoon suffered yet another defeat in an attempt to halt the ongoing proceedings by the 5-member committee set up by President Mahama to probe 3 petitions seeking her removal, as the Supreme Court, by unanimous decision, dismissed her injunction application. This ruling was delivered hours after the Apex Court, also by unanimous decision of 5-0, struck out her supplementary affidavit because it discloses information meant to be kept in camera in line with Article 146. The court earlier dismissed a preliminary objection filed by the Attorney General seeking to remove Justice Scott Pwaman, Justice Adibwe Siedu, and other members of the Precedent Committee from the list of defendants. Suspended Chief Justice Torkornoo's injunction application was aimed at halting the proceedings of the Justice Pwaman-led committee and also seeking the constitutional interpretation to permit her to waive her right to a private in-camera hearing. She was also praying the Apex Court to declare the prima facie determination by the 6-member committee, which comprises of Justice Gabriel Scott Pwaman, Samuel Kwame Adibwe Siedu, Daniel Yaldemelevo, Major Flora Bazuwarua Dalagu, and Professor James Sefa Jiasa as unconstitutional and bar its members from continuing the process. The application also sought to bar Justice Pwaman and Adibwe Siedu from presiding or participating in any deliberations of the committee. Further, the Chief Justice was also asking the court to suspend the operation of the warrant for her suspension issued by President Mahama under Article 146(10) of the Constitution until a final determination is made on the matter. In court today, Deputy Attorney General Dr. Justice Rimsai, representing the state, argued that the writ did not explicitly name the committee members as parties intended to be affected by the suit and therefore asked the court to remove them as defendants. However, former Attorney General Godfrey Eboadame opposed the objection, arguing that what matters is whether the reliefs are being sought against the individual, which in this case he said clearly involved the committee members. The 5-member Supreme Court panel, chaired by Acting Chief Justice Paul Bafobone, ruled in favor of Dame's position and dismissed the objection. The court also, by unanimous decision, ruled that the supplementary affidavit filed by the suspended Chief Justice discloses information meant to be kept in camera in line with Article 146 and thus struck that out. The court also said the suspended Chief Justice's injunction application had no legs to stand on, hence it was dismissed. But the head of the legal team of the suspended Chief Justice, Godfrey Dame, after court, in an interview with the media, described the process as flawed.
Not surprising, because really follows in the theme of what we've been witnessing. But yeah, I think that we move on. The lot of battles that we can fight. We think that the process is flawed, no doubt. Heavily flawed, laden with all kinds of constitutional violations. And I'm quite surprised that the Supreme Court will be more or less acceding to the perpetration of such violations against the highest judicial office holder. It's not about Justice Torkornoo, as I keep saying. It's not about Justice Torkornoo at all. The issues are far-reaching. They actually impinge on matters which affect the independence of Ghana's judiciary, the security of tenure of judges and all. But if the Supreme Court, for whatever reason, that don't seem to take that view, well, so be it. I think that in future, the whole nation will get to know the consequences of this. I'm not here to disclose to you my line of action or plans. But clearly, what we can say is that this is a procedure that should be deplored. There cannot be a situation where the Chief Justice cannot face an inquiry set up under Article 146 of the Constitution to determine some inquiries against some petitions against her, and she's not had notice of the specific charges in respect of which the prima facie case has been made, the basis for such charges, and the reasons why she's supposed to go through the inquiry. This is a basic right that is available to every citizen of the country. It's not an account of her being a Chief Justice or her requesting for the grant of higher rights than as are due ordinary citizens. It's for basic constitutional right. The notice of charges that she's standing trial or she's supposed to respond to, the basis for saying that's the case for her to answer. And indeed, this is a very significant point. It's a decision that resulted in her suspension. Are you saying that she cannot know the reason why she was suspended? She cannot know the specific charges on the basis of which the president said that she should go and stay at home and for another person to assume her office. I mean, this is very strange. It's something that is very much alien to every civilized legal system. But we'll see. We'll wait the reasons and then we'll deal with it. Due process, rule of law, constitutionalism must prevail in Ghana. That is what we seek. It did not, on account of people putting pressure on the CJ to resign or do whatever, that we will take a decision. The most important thing is that there must be an upholding of the rule of law in Ghana. And we will continue to assert our rights. Proper thing must be done. As far as I'm concerned, the proper thing must be done. And she's a Chief Justice. She's been in office. She's been a judicial office holder for more than 25 years or so. She's been at the bar for almost 40 years. She knows what is due process. She knows what is constitutional rights. And I think that's what she's asking for. And how can it be correct that a judge who sat on two matters on which she also sat and be called as witness in a petition against her, and that same judge be made the chairman of the committee that is supposed to inquire into the petitions against Chief Justice? Clearly, it's untenable. It's only in this country that, I don't know. And the question is, on what account can she be singled out for removal from office when indeed she did not sit even alone? She sat as part of a panel.
So that's the head of the suspended Chief Justice Torkornoo's legal team, Godfred Yeboah Dame. Let's go on Zoom and speak to a friend of this program, Theophilus Chimega Jr. He's a private legal practitioner. Counsel, grateful once again for your time this evening on 505. Can you please unmute for me? Yes, I can hear you. I can hear you. So yesterday we were talking about this injunction, 5-0 decision unanimously dismissing the injunction. They say it has no leg to stand on. Again, they struck out the supplementary affidavit filed by the Chief Justice saying that it discloses information meant to be kept in camera in line with Article 146. Godfred Dame says this process is flawed. What do you make of the court's decision?
Well, good evening, and good evening to your listeners and viewers worldwide. Yesterday, we sort of predicted that this was going to happen. Reason being that there have been a series of injunction applications that have failed, and we didn't see what else could have come better than what has been argued previously. And yesterday, I sounded a word that, if you notice the history of applications to remove the CJs, the Supreme Court sort of tried to protect the CJ, and nobody knows why currently the current panel appear to always rule against her, and things are not moving in her favor. It is high time. I have been maintaining this from the first day that she throw in the towel and call it quits. Unfortunately, her lawyer said nobody can force her to quit. Yes, the Africans have a proverb that says that it's only the stubborn fly that follows the corpse to the grave. So sometimes you smell the coffee, you know what sort of breakfast is being prepared for you. We know that this was dead on arrival. The Supreme Court, of which she is a member, or she was a member until her suspension, has held that you cannot injunct state institutions from performing their duties, their statutory duties. And they've not been able to point out any law which has been breached apart from emotions. And multitude of emotions cannot constitute law. The law is the law, if I'll put it. So for me, I wasn't surprised at all.
Again, she was asking for interpretation. So Article 146, and she says that I want to waive my right for that in-camera hearing. It is my right. I want to waive it. Is it to suggest by the ruling that now the Supreme Court cannot interpret or interfere in any case based on the same Article 146 that was brought by the suspended Chief Justice?
As I explained yesterday, you know, the article does not apply to only the suspended Chief Justice. She's not the only one who will be in camera. The panel members are also in camera. The witnesses in camera, the petitioners in camera, and their lawyers are supposed to be in camera. So are they going to waive the camera for her and the others will talk from behind scenes or behind cardboards. That cannot happen. Much more, the article is a constitutional mandate. You see, I mentioned again yesterday that few people will be talking that being a CJ, she will be presumed to have been the one who should have known all the laws we have in Ghana. So it's a bit confusing and a bit unfortunate that simple things like this they tend to do. It will yield nothing. It will yield nothing. If it is not that they should not be sacked from the altar of justice, they would have thrown them away long ago and would have given them some hefty cost. So now the Supreme Court has rightly said that they cannot injunct, they cannot remove that veil. They cannot remove that veil. Hello, can you hear me?
I can hear you.
Yes, they cannot remove that veil for just her alone, because it is not, she's not the only one who is taking part in the proceeding. And for you to disclose a number of things that are happening that are supposed to be in camera, what are you doing? And you expect them to condone it with you? No, they cannot condone that, because the issue is that he who comes to equity must do equity. You can't be doing bad and come to them to say that help me to do good thing or help me to continue doing the bad thing. Nobody will agree to that. So for me, I wasn't expecting anything apart from what we saw today.
She's raising issues of unjust and unfairness. We know that this is a process. The committee hearing is a process where there will be no avenue for appeal. So she goes through the process. She's found maybe guilty of a sort. The committee makes recommendation, and that's it. She's taking out. There will be no avenue for an appeal. So I mean, if people feel that their rights are being trampled upon, it's the courts that they have to go to enforce that. So if this is coming at this time, then is the court not maybe ready to ensure that her rights, listen to her about the concerns of unjust and unfairness? Because the court in the ruling is saying that, oh, you cannot, the process is still ongoing. So once the thing is ongoing, you can't come before us and want to stop it. Let the process continue. But this is somebody who feels that the process is unfair and it's unjust. So once she goes through the process and she's taking off, her rights have been trampled upon.
See, you don't just, for you to seek an injunction, you must have a right at law or at equity, which looks threatened or which is being threatened or which is being abused, that you seek the court's intervention. Which of the rights is she talking about? The right to non-camera hearing or the right to camera hearing? If it is the right to non-camera hearing, it doesn't exist. So you cannot seek to have a right which is not existing. Cannot seek that right which is not existing.
She's talking about the right to stop the hearing because she feels the process is unfair.
Yes, but you need to point out which part of the process is unfair. You have not pointed out any part of the process which is unfair. For you to talk about the location, where does she want us to do it? She says the judicial building. Now the judicial building, did they use it for the hearing involving a chief justice? No, use it for other judges. It doesn't mean that should always be the place that this type of hearing should be. She says that using the Osu Castle. In any case, until this her supplementary affidavit came out, a lot of people don't even know where the hearing is taking place. Now you have told the whole world where the hearing is taking place. So you have removed the veil of the camera that is supposed to be there. So how can you turn around, having done all this in public, and say you have a right to be protected? You know, now you have put even the witnesses and the petitioners at risk, because people will now go stand by the gates or stand on the road to Castle Osu and be looking for who will be the witness and who will be the petitioner. You don't have to do that. You do that, then you come back to the court for the court to protect you. It doesn't work that way.
Okay. Counsel, we are very grateful for your time this evening. That's lawyer Theophilus Jimaga Jr. He's a private legal practitioner. And there have been several reactions to this court issue by the former, the suspended Chief Justice. We'll bring that to you subsequently. Martin Amidu has written extensively on her, and let me read two excerpts of that. He says, crying and begging, Amidu blasts Chief Justice over reaction to the suspension move. The former special prosecutor Martin Amidu has launched a scathing attack on Torkornoo, accusing her of abandoning the dignity of her office amid efforts to remove her through a constitutional petition. And you know, Martin Amidu for this open letter. In that open letter, he claimed, and I'm quoting, the Chief Justice of Ghana, Mrs. Torkornoo, has since the initiation of the petitions to remove her from office thrown away all the decorum and respect demanded of her high office and started behaving like a childlike manner of crying, ingratiating, begging and appealing to the emotions and sympathies of her colleagues in the Supreme Court. That is the constitution and law of Ghana until the same court decides in the future to depart from its own previous decisions. He goes on to say that 3 recent Supreme Court dismissals of applications for the injunctions aimed at restraining public officers under Article 146, 2 of which were dismissed on May 21, 2025, as suspiciously coordinated, as though already choreographed and agreed by a scripted plan. After the Supreme Court dismissed the 2 interim applications, the Chief Justice herself on the same day, May 21, 2025, at 3 p.m., commenced an action by writ asserting her right to a public hearing. Martin Amidu went on to explain that the Chief Justice's writ challenged the suspension warrant issued by the President and sought to restrain the committee members from proceeding with the petition. He questioned the motive behind the move, stating, and I'm quoting, the writ without statement of plaintiff case and motion for interim injunction without accompanying affidavit were instantly published by the media. So he thinks that this is a coordinated attempt. Let's stay on matters related to the judiciary, because Chairman Wontumi, that's the Ashanti Regional Chairman of the New Patriotic Party, Bernard Ntwibu-Esiako, will have to spend another night in custody because as his lawyers are working to meet that bail condition that has been granted by the Economic and Organized Crime Office. They have unfortunately been able to meet it today, so they'll go ahead tomorrow. But former Vice President Dr. Mahmoud Bawumia, 2024 NPP flag bearer, has waded into the matter. He is urging the Economic and Organized Crime Office, YOCO, and other security agencies to uphold the constitutional rights of Chairman Wontumi. Some NPP executives as well as party members stormed the YOCO head office from last night after Chairman Wontumi was picked up after his visit to the police CID, demanding his release, and that led to the assault of a journalist in the process. Now, in a Facebook post, Dr. Bawumia said, and I'm reading to you that Facebook post verbatim, I am deeply concerned about the arrest and continued detention of the Ashanti Regional Chairman of the New Patriotic Party, NPP, Mr. Bernard Ntwibu-Esiako Wontumi, particularly as the charges remain vague and his whereabouts remain unknown. In a democratic